This is Duke University.
Constitutional limits of Congress's enumerated powers. I am going to very briefly just say everybody's name, and then I will be giving the presentation of Ilya's paper and then some comments, and then Matt will be doing the same thing for Stuart's, and then we'll get to the panelists. I will be a little bit nudgy on time, just so that we get more of you in, since that was so nice to get some interaction with the audience at the end of the last panel. So, people participating: Ilya Somin, Erwin Chemerinsky, do you know Erwin Chemerinsky, who you saw in the last panel, Stuart Benjamin, Matt Adler, and Jamie Boyle. You can see their illustrious achievements in the descriptions in your packet. And now let me turn to a few comments on Ilya's paper, and a brief description, and then a few comments from me. So as was noted in the last panel, Ilya's focus here is on analyzing a particular claim that has surfaced repeatedly in this debate, the claims of a slippery slope. And in his paper, he notes that these claims surface both for and against the individual mandate. The claim against the mandate takes the form of the charge that we heard: if Congress can require individuals to purchase health insurance, it can mandate that they purchase anything, homes, cars, and the infamous broccoli. The argument in favor of the mandate is that holding, the slippery slope argument, is that holding Congress lacks power to require individuals to purchase health insurance will inexorably lead back to the type of unduly narrow and restrictive views of congressional power that dominated during the Lochner era and the early New Deal. Now, Ilya argues that as a matter of both logic and factual reality, the slippery slope claim in favor of the mandate fails. It fails because a prohibition on congressional regulation of inactivity would have a limited impact on existing precedent, and because the court is unlikely to adopt a broader view. But he maintains that the slippery slope argument against the mandate has merit, because absent some distinction between activity and inactivity, any failure to purchase or decision not to purchase logically can be deemed economic activity or part of a larger regulatory scheme. He disputes the idea that there is anything about health insurance that can logically distinguish it from any other mandate. He makes a similar claim about the tax argument, that if the mandate is a tax, then Congress can impose any purchase requirement by dint of imposing a tax. And he also argues that these outcomes may not be as factually unlikely as many had supposed. The one argument, analytic argument, to the contrary, that he suggests might be able to logically limit mandates in the future is the collective action approach that we were just hearing so much about. But he emphasizes the key point that the discussion focused on, the variable of how closely the courts scrutinize a claimed collective action problem. And he disputes the idea that health insurance provides such a problem to justify regulation here. Okay, so there's my summary, and let me just give a couple of comments. I think in his assessment of the slippery slope arguments, I think Ilya is partly right, but largely wrong. And I will give him credit, though, as venturing into the fray. I think Ernie made the point the masks are off. And to Ilya's credit, he has come to engage with folks who he knew probably didn't necessarily agree on the merits. So I think he's, I'll say a little bit of why I disagree with his arguments. I also want to hopefully have some time to make a couple of comments about slippery slope arguments as a form of constitutional argumentation. Okay, so where I think Ilya is right, I think he's right in arguing that the slippery slope argument in favor of the mandate's constitutionality doesn't hold as a logical or empirical matter. Here I think I disagree a little bit with Erwin. I want to be clear, I think that the mandate is clearly constitutional under existing doctrine. I think any inactivity-activity distinction would mark a change in current doctrine. It would be significant. I am, however, skeptical that such invalidation of the mandate under inactivity or activity or some other basis would necessarily lead to a radical change in the scope of Congress's powers. I think it's one that could be analytically cabined. It might be an artificial cabining, but nonetheless, it's one that there are some logical moves the court could make. Similarly, on the tax front, the court could say, for example, maybe Congress could have done this to the tax power, but as a matter of statutory interpretation here, it didn't. I think that's wrong. I think there's plenty of support for arguing Congress did intend this to be a tax. The point is simply, logically, analytically, the scope of such a holding would be much more limited. The main point that I do want to emphasize, and this I think maybe where I disagree a little bit more with Erwin, is I actually think that the court would likely limit the disruption that its decision would cause. I see not that much appetite, in Ilya's terms, on the Roberts Court for forcing fundamental change in the federal government. And I base that point in part on my own assessment of the ideology of the Roberts Court, which I see as more anti-regulatory and pro-business than pro-state. And federal power is actually quite useful to preempt state regulation on top of any incrementalist tendencies on the conservative justices on that court. For sure, they're conservative. That doesn't mean they want to take us back to the early New Deal. What I would expect to see here as a model, if they were to invalidate the mandate, is something along the lines of free enterprise versus the PCAOB, where the court adopted the conservative Unitarian executive view of a very formalistic limit on the extent to which Congress can restrict the president's removal power. But it did so in the context of essentially acknowledging the constitutionality of independent agencies as they largely exist today, and signaling it wasn't going to do anything about the civil service or other kinds of restrictions, right? So it's a formalistic line enforced by a conservative court, but one that doesn't really challenge too much about the structure of the modern administrative state. Okay, that's where I agree with Ilya. Now, my disagreements. I think that the slippery slope claim against the mandate doesn't have that much more merit. I think it's in fact open to exactly the same critique. It characterizes a logical possibility as a logical necessity, and it's also empirically unsupportable. On the empirics, I'm actually just going to echo what Erwin said in the first panel, rather than take up more time. I think unless the politics of this country change dramatically, the idea that we will suddenly see purchases to buy GMs or broccoli or whatever it is highly unlikely. Similarly, I think the idea that Congress is going to be passing a lot of taxes to achieve that is quite dubious. I also think that one of the empirical points to note here is what we see from the court's behavior, what we see from the court's behavior in Lopez and Morrison. I think that what that signals is that the court's going to intervene when it sees Congress overreaching and in its view. I don't think that many, at least some purchase mandates, I'm not at all sure would be best characterized as overreaching. I do think that the court is going to see a raft of purchase mandates as overreaching, and I think it would intervene. Were it to do so, I think there are a number of ways that it could cut off Congress's regulation. I think it could do a kind of anti-bootstrapping move, or the kind Stuart's paper suggests, on a limited basis. Something maybe akin to what Neil was suggesting, but at any rate, you can't create economic activity simply by the regulation at issue. My guess is that what they will do, if they intervene, is really scrutinize more the interstate commerce connection. I would think that Justice Kennedy's concurrence in Comstock on the need for a tangible demonstrated link to interstate commerce is probably the likely way the court would go. This is, again, back to Jack's point about the critical element of deference or not. I also think that in the future, if they want to distinguish the healthcare mandate here from future mandates, empirically there is a basis for that. Here I disagree with Ilya. I think that actually the facts of healthcare and the health insurance markets are particularly strong in showing a tie to economic activity, and that the court in the future could distinguish. Okay, Ilya denies that these are distinctions that are defensible. In doing so, as just a sort of theoretical point, I think that his argument too much suggests that economic activity and closely related to a broader regulatory scheme has some kind of independent either empirical or independent logical meaning. These are judicially created terms to serve a judicial function. And if the court wants to cut back in the future, it has the analytic means in those terms to do so. I don't think that logic in that way is what drives judicial analysis. And at any rate, I don't think that any of the ways that the court could cut off future mandates is any more artificial than the inactivity-activity line, so I don't see any reason to distinguish between the two versions of the slippery slope slide. Okay, now just a couple of comments on slippery slope arguments. This is a familiar form of constitutional argumentation, right? And it's a dynamic that we can see. It seems real. We can identify some context, right? If you think about substantive due process and Griswold and the openings that were created, it seems like there might be some real merit to this dynamic. Just a couple of concerns. One is, I think it's easy to think that what is driving there is the doctrine rather than politics or cultural movements that the doctrine inherently is reflecting. I also think that slippery slope arguments are quite troubling for the degree to which they move away from the focus of the case at hand. Fred Scharr has this formulation that the key characteristic of a slippery slope argument is that it is not making assertions that the instant case is objectionable, it is the future case that is the problem, right? But when you're talking in particular about congressional regulation, rejecting what might otherwise be an acceptable form of congressional regulation for fear of future abuse is an unusual assertion of judicial power. Judge Marcus on the 11th Circuit made this point in response to the parade of horribles that the majority had given by stating that as courts of limited jurisdiction, we ought not to lose sight of the legislation before us. There might be, and I think there probably are, some contexts in which the substantive content of the constitutional claim justifies a kind of prophylactic approach. I think it's very odd to do it in the case of congressional power. Here, the presumption is supposed to be in favor of constitutionality rather than in the opposite direction. There is also the concern, and I think we see it in the debates on the mandate, the slippery slope arguments lead to very results-based reasoning that don't necessarily tie in to the kind of core elements of constitutional reasoning we usually see, right? So we have to have the inactivity-activity distinction because otherwise there's no limit on Congress, but that doesn't tie it particularly to the text, structure, history, precedent of the Commerce Clause. A lot of people have talked about how the roots most overtly seem to be more in the individual rights provisions, even if you see federalism as an individual liberty protection as it has some historical basis for connecting. Nonetheless, inactivity-activity is not the way that has mapped over time, and you still have to draw that connection in ways that aren't intuitively obvious. Just to close, I think that these objections to slippery slope arguments are the kinds of things, particularly the right concern, right? The idea that there's nothing wrong with this case, but I'm worried about that one, so I'm going to hold this one unconstitutional. Those are the kinds of arguments that the court ordinarily, in quotes, would take quite seriously. If it doesn't here, if it gives them more weight, that does, I think, give more weight to Erwin's concerns about ideology driving. My own guess is that if the court strikes it down, it's not going to make the slippery slope argument the core of the reason for doing so, as the 11th Circuit did. Instead, it will do something more akin to what it did in Lopez, which is to say this case is objectionable, and also we have to draw a line to keep some limits on it. But I'm curious to know what other people think about that, particularly Ilya.
So thanks very much, Gillian, for your thoughtful comments. I think I will start off very briefly by talking about the part of the paper that Gillian didn't really say much about because she at least mostly agrees with it. Then I'll talk about what I think are three major objections to the part that she disagrees with. First, her argument that really, or echoing Dean Chemerinsky, that really the political process will take care of slippery slopes. Second, that even if it doesn't, the court would have doctrinal resources to do so on its own. And then third, some of her general remarks about slippery slope arguments and their possible problems. So first, briefly talking about sort of the part of the paper that she sort of passed over, I'd just like to briefly mention what, in fact, the slippery slope arguments in favor of the mandate are. And I'm not going to discuss in great detail my answers to them, but it's worth throwing them out for those people who have not read the paper. So I think one of the most commonly heard ones is the claim that if you strike down the mandate, they'll be going back to the Lochner era and striking down all sorts of other economic regulations. I respond to this on two bases, really. One is that in the Lochner era, of course, the courts were striking down both federal and state regulations, actually primarily state ones, whereas this litigation have no impact on state regulations. Second, even with respect to federal regulation, virtually all federal economic regulations enacted so far do regulate what can pretty easily be described as economic activity, commercial transactions of one kind or another. So they would that doctrine would remain in place even if the mandate were struck down. The second kind of argument that is made is that, I think this is a somewhat better one, is that if you strike down this mandate, that would prevent Congress from enacting other mandates in the future, which might be necessary in an emergency situation, like, for instance, a mandate that people get vaccinated during an epidemic and the like. I think this is a better slippery slope argument than the Lochner one, but in the paper I still describe why I think it's incorrect. In particular, in most realistic situations could still be dealt with within the existing doctrine. Other ones could be dealt with through state regulation rather than federal. Finally, there is the argument that regardless of what actually is true as a matter of doctrine, sort of winning this case for the anti-mandate side would generate momentum for restricting congressional power in other ways through the courts. I think, to make a long story short, this is theoretically possible. After all, as we're going to hear later in the class, later in the seminar, it will be the conference, it will be the case that there are connections between constitutional law and politics and political movements and the like, and certainly if this statute is struck down, it would be the most important federal statute struck down on limited powers grounds in many decades. At the same time, as Gillian mentioned, I also think in order for this kind of slippery slope to really occur, there would likely have to be some change in the personnel of the court and also probably greater political momentum for constraints on federal power than currently exists. I also mentioned that, in my view, actually, if such a slippery slope did occur, at least to some extent, in my view, actually would be a good thing. But the purpose of this paper is not so much to analyze whether a particular slippery slope is a good thing normatively, but to analyze whether it in fact exists as a matter of logic and empirics. That's why this paper is not actually attempt to be a comprehensive evaluation of whether the court should uphold the mandate or not, but it does evaluate a particular set of arguments that have been prominent in both sides. Now, Gillian, in her initial comment, says even if logically speaking any mandate might be permissible, it would be taken care of politically. Sort of the broccoli mandate, the public would never stand for it, so we don't really have to worry about it in real life, even if it matters a matter of judicial doctrine. In the paper, I give some analysis to why that might not be the case. In particular, we have some mandates can be enacted out of special interest group influence. Obviously, there are numerous industries that lobby in Congress to pass special interest legislation, and plenty of it gets passed even if there's not necessarily strong public support. In some cases, because much of the public may be ignorant about it, or even if they know about it, they're not going to act forcefully on it because it matters much more to the interest group than it does to them. Second, it's not necessarily the case that such mandates will always be unpopular. There's a long history in law and politics of so-called bootlegger Baptist coalitions. There's the famous story how prohibition was enacted partly because the Baptists wanted it, people who for moral reasons wanted to get rid of alcohol drinking, and of course bootleggers liked it too because bootleggers do better when alcohol is illegal and there's a black market for them to exploit. So similarly, you can easily imagine bootlegger Baptist coalitions here as well. For instance, even in the case of the broccoli mandate, broccoli really is very good for you. There's a lot of data to support that. I cite some of it in the paper. And obviously broccoli producers would be happy to have a broccoli mandate, and it could easily be argued that such a mandate or a mandate that people have healthier diets in general would be good for public health. And there's many, in some cases, quite onerous regulations that have been enacted over the years by these kinds of bootlegger Baptist coalition. There's no reason to suppose that mandates are a special case where this would not happen, even in just much the same way as it happens in other areas. Now, Gillian says, well, even if that was going to happen, the court would still have doctrinal resources to distinguish this mandate from other kinds of mandates. And, I fully recognize that, the court doesn't always have to be logical, and they can just say, well, it's different just because we say it's different. But as a matter of logic, in the paper, I go through the different kinds of arguments for why this case is supposed to be special, and, they don't really stack up very well. One claim, the most commonly heard one is, well, everybody uses healthcare at some point in their life. Notice, however, that this shifts the focus from health insurance, which certainly not everybody uses and which is the focus of the mandate, to healthcare, which is a broader concept, and you can use a similar frame shift to justify any other mandate. As was said in a previous panel, you can shift the focus from broccoli to food. Everyone uses food. In fact, it's much harder even to avoid the food market than the healthcare market. Just try avoiding food and see how far you get with that effort. I don't think it would really be a very successful experiment. And I can say the same thing as was said in a previous panel with respect to cars and transportation, going to the movies and entertainment, almost any other situation that one can imagine. Similarly, I would say the same thing with respect to some of these other arguments, like the tax argument that if this is a tax because it's a fine collected by the IRS, then any mandate to purchase anything can be imposed in that way. In the paper, I discuss collective action federalism as a possible constraint, Neil Siegel and Bob Cooter theory, but I note there it all depends strongly on the question of how much scrutiny there really will be whether this is a collective action problem or not. In the paper, I essentially argue that if the scrutiny is not very strong, then you can justify certainly virtually any purchase mandate, including the health food purchase mandates. In fact, you can make an argument very similar to the one that Neil made on the previous panel, that there would be a great public good for the states if all of them required people to eat a healthier diet. That would improve the economy, reduce healthcare costs, and so forth. But if a single state did it, then they would experience outmigration because people would prefer to live in a state where they can eat a tastier diet, even if it's less healthy than the one in the broccoli mandate state. So I think under relatively mild scrutiny, that could easily pass. So we could perhaps talk later about particular doctrinal limits that could be imposed. I think Gillian was not as especially detailed in explaining what they are, but so far I don't see it. Lastly, Gillian makes some general comments on slippery slope arguments and whether it's desirable to use them. She says, well, it shifts the focus away from the individual case. I think actually with respect to the Supreme Court, to some extent, that's a feature, not a bug. The purpose of appellate courts, especially the Supreme Court, is to set down general rules for lower courts that are going to be followed going forward, not just sort of an ad hoc solution to a particular case. And so I think it is important to focus our attention on the strengths and weaknesses of the general rules that they set down. And I think that's an essential element of constitutional doctrine generally, and particularly constitutional doctrine established by the Supreme Court, where the Supreme Court's main function is not so much to collect or to correct specific individual errors that lower courts might make, but to set down more general principles that lower courts are supposed to follow going forward. So I think I've covered some of the major points that Gillian has raised, and obviously there are other issues that I'm sure we'll discuss as the panel goes on. So with that, I conclude, and I very much look forward to the questions and discussion. Thank you.
Great. Jamie, I think you're next, right, on Stuart? Am I getting
No,
it right? No,
Matt.
Matt is
Okay.
next. No, sorry.
All right, bootstrapping. So what's bootstrapping? So roughly speaking, we can say that bootstrapping occurs when some actor or entity has a grounding for doing Z only because it's previously done Y. Let's just sort of put that out there as a rough definition. Now consider these arguments for why Congress has the power under the substantial effects test to impose the individual mandate, that is to regulate the activity of self-insuring. One argument is that self-insuring has a substantial effect on hospitals because, of course, when the person who self-insures ends up incurring a catastrophic health event, he or she will show up in an emergency room and the hospital has to provide care. Another sort of argument for why Congress has substantial effect to regulate self-insuring is that by self-insuring, particularly if a healthy person self-insures, he or she takes himself or herself out of the universe of people who are purchasing insurance, thereby raising their costs of insurance. Now, critics of the individual mandate, like Randy Barnett, for example, argue that these two substantial effects claims, showing a substantial effect between the activity of self-insuring and costs on hospitals or costs for insurance company or insured people, represent a kind of bootstrapping on the part of Congress. The claim is that the only reason there's a causal relation between self-insuring and costs for hospitals or costs for insurance companies or other insureds is by virtue of prior congressional mandate, right? So in the cost for hospital case, that comes in by virtue of the Emergency Medical Treatment and Active Labor Act, which says that if you don't have insurance and are judgment proof and show up at a hospital, the hospital has to treat you. Note that if hospitals could decline to treat you, then self-insurance would not have this causal effect on hospitals' costs that the substantial effect argument makes. Similarly, the reason that self-insurance changes the premia of people who buy insurance is just because insurance companies cannot sell insurance after the ACA based on health history. They have to engage in community rating. So again, the critics say there's a kind of bootstrapping here. Absent this prior legal requirement that insurance companies need not take account of pre-existing conditions and engage in community rating, there would be no substantial effect between the regulated activity, self-insuring, and interstate commerce. So there's a kind of bootstrapping challenge to the individual mandate, and Stuart in turn responds to that, right? And he responds to these bootstrapping arguments through a very rich and general analysis of bootstrapping, and I really recommend the paper to you. I'm not going to go through it in great detail, but there are two, at least, important themes. One is that bootstrapping is just pervasive. Bootstrapping occurs all the time. So one example he gives is of the Supreme Court bootstrapping its own precedents, right? Often, the Supreme Court decides case Z, but that's the right answer only because of prior precedent Y. It's a kind of bootstrapping. Another example Stuart gives as a really distinguished First Amendment lawyer is congressional regulation of broadcast as opposed to the internet, right? The court has held, so for example in the Reno against ACLU case, that the reason for more limited or more lenient First Amendment scrutiny of congressional regulation of broadcasting is just because congressional regulation of broadcasting is pervasive. So by pervasively regulating broadcasting, Congress has sort of bootstrapped itself into more power, less First Amendment scrutiny of its own regulation. The second point Stuart makes is that it's very hard, if one really wants to have an anti-bootstrapping doctrine, and particularly with respect to the Commerce Clause, if one really wanted to say, well, no, Congress doesn't have the power to regulate activities having a substantial effect on interstate commerce, if that represents a bootstrap, you'd need to make some distinctions, right? An anti-bootstrapping doctrine that broad would be much too broad, and so you need to distinguish, for example, between Congress bootstrapping itself into power to regulate activity versus inactivity, or some connection to congressional purpose, or some kind of distinction Stuart talks about between simultaneous and non-simultaneous bootstraps. And Stuart works through all the different kinds of distinctions that might figure within anti-bootstrapping doctrine and says none of them make sense. All right, so that's sort of a rough, quick summary of the paper. So let me just raise some skeptical questions. And again, I think it's a really rich and interesting paper, but just to provoke some discussion. I think the case of the precedent bootstrap is different than the bootstrapping concerns with the ACA. So in the precedent case, what we have is a kind of a justification bootstrap. That is the correctness, the justifiability of a particular Supreme Court decision hinges on a prior decision. Here, the issue is not just the justifiability of the ACA, but Congress's power to do so. Right? So we might distinguish between justification bootstraps and legitimacy bootstraps, and power bootstraps are sort of a subset of legitimacy bootstraps. In other words, but the point is that within a very broad range, however the Supreme Court decides the case, one way or the other, it's legitimate in doing so. It might be wrong, it might be unjustified, but whether it decides the case, this way or that, either decision is legitimate. Here the concern is the legitimacy of congressional regulation, namely that Congress simply lacks the power, right, to impose an individual mandate. So intuitively, concerns about, a legislature, in particular Congress, bootstrapping its own legitimacy are more serious than justification bootstraps, where simply the justifiability of some decision at some later time hinges on a prior decision by the decision maker. Now, Stuart can surely point to other examples of legitimacy bootstraps. So, for example, the First Amendment example, where the very legitimacy of congressional regulation of broadcasting in a pervasive way hinges on the fact that Congress in the past, regulated pervasively. But I think we're going to feel uncomfortable about that case. That seems problematic, right? Any kind of case where an act, or at least a governmental body, bootstraps its own legitimacy, as opposed to simply, the policy advisability of its decision, is going to seem troubling. The other thing to note here, and this is sort of a footnote, again, going to the point that bootstrapping is pervasive, is that, at least for commerce doctrine, the concern of bootstrapping arises only with respect to certain types of Commerce Clause doctrine. That is, if we were in the world of the old sort of direct effect test, where the question was the regulated activity, or is the regulated activity literally interstate, then it's sort of hard to see how Congress could bootstrap itself. That is, Congress regulates an activity, either it's interstate or not, and that test being satisfied doesn't depend on prior congressional decisions. Right? By contrast with substantial effect, which does raise the specter of bootstrapping, that is, congressional regulation of Z only has substantial effect by virtue of prior, or independent congressional regulation of some other activity Y. All right, so how much time do I have?
You have 2 more minutes.
All right, so I'll be quick.
2.5.
So why would, again, focusing on legitimacy bootstraps, and in particular on this kind of power bootstrap, concern with Congress bootstrapping its own power, why would that make sense? I mean, one possibility is just, a principle that Congress's power has got to be limited. We have to find some limit. And so, when Congress has power by bootstrapping as opposed to by, in some other way, we're going to say that's problematic. And Stuart, I think, is skeptical about this argument, and I sort of agree. In this paper, he talks about sort of a consequentialist argument for bootstrapping, and I take it what he means there is sort of an intrinsic concern with bootstrapping itself. That we're intrinsically troubled by Congress having power by virtue of its own bootstrap as opposed to in some other way. And it's hard to see why, if Congress has power, we should make that distinction. I mean, I think a better rationale for an anti-bootstrapping doctrine goes to themes of under-enforcement that Ernie Young is going to raise. That is to say, and this also next to Neil's paper, I mean, if one sees the underlying principle of the Commerce Clause as being something like Congress has power to regulate when there's a good reason for federal regulation, when there's a kind of a federalism failure, right? When the states are not up to the task. As Ernie's pointed out, it's very, very hard to see the court directly enforcing that principle, and so the court needs intermediating doctrines. And an anti-bootstrapping principle might well be part of those doctrines, right? We might have doctrines which more or less, which are easier to apply, and more or less track the case, track the underlying principle for congressional regulation, and it's quite possible that these intermediating, judicially applicable doctrines are going to include some anti-bootstrapping principle. The other thing I'd say there on that count is it's not clear why these doctrines might not make reference to legislative purpose. I mean, intuitively, the problematic cases where Congress regulates some activity with the specific purpose of creating a substantial effect with respect to some later activity. Right? So it's not just bootstrapping, but again, regulating with the specific purpose of bootstrapping. And Stuart is, again, has a wonderful rich section, which I'm not going to try to summarize in my, negative time allotted here, talking about the difficulties of purpose tests. But I would note that there are areas of constitutional law where the court very seriously looks to legislative purpose. So equal protection law in particular, right, looking for discriminatory purpose is a real part, like it or not, of the doctrine, right? In lots of areas, most recently the districting cases, the court tries to figure out whether a state legislature's purpose in districting was racially discriminatory or not. So it's not unthinkable to have an anti-bootstrapping doctrine proxying for a deeper Siegel-Cooter style good reason for federal regulation doctrine that makes reference to congressional purpose. So in 10 seconds, I think it's a bad idea. So at the end of the day, I would end up where Stuart does, but for a different rationale. I think the reason that would be problematic is that would be as difficult for the court to administer as just directly looking to whether there's a good reason for federal regulation. So in the equal protection case, the reason that Congress looks to purpose is because, or arguably because, there's an intrinsic concern with prejudicial purpose sort of corrupting the legislative process. Here, by contrast, the real test, a la Siegel and Cooter, and I agree, is something like, is there objectively a good reason for federal regulation? To try to look to that, or to administer that, by looking to whether Congress had a subjective purpose to bootstrap, would be quite roundabout and costly, and would be no less costly than directly applying that test. So I end up agreeing with Stuart that it's hard to see why Commerce Clause doctrine should incorporate an anti-bootstrapping provision, but just to stress that the concern here is not bootstrapping justifiability, but bootstrapping power, and that if one thinks about this in terms of under enforcement, the viability and possible plausibility of the anti-bootstrapping doctrine might at least be thinkable.
Great. Stuart.
All right, so that was great, and you've now summarized enough that I can jump right into a couple of things. So one is, I think that the pervasiveness is not merely in the context of precedent. This goes to this question of how much it would do if we try to say, well, for reasons of under-enforcement, whatever else, we want to try to cut back on bootstrapping. Everything that Congress, by the way, would be clear, I'm distinguishing bootstrapping from just an ordinary slippery slope path dependence. In particular, bootstrapping is empowering oneself. So you are creating the conditions for your future regulation. I submit to you that everything that Congress does is bootstrapping on things that previous Congresses did. And so how is it today that Congress can regulate banking, in part because it created the conditions that allowed for the rise of banks in the first place? It set a whole, and we can keep on going back. How do you regulate various kinds of interstate transportation, in part because Congress decided to build interstate highways, and you try to unpeel the onion and you get back to Sacagawea. There's no sort of stopping point, because everything that Congress has done is relying in part on what its predecessors did. So even taking courts out of it, because I note that I think there are arguments one could make, not only Matt's point about justification versus legitimacy and power, but you also just might think, look, when courts decide, they have to decide. They have to choose Y or not Y. And so if they then choose Y and then that enables Z, that's a little different because they were forced to make the choice in the first place. Whereas Congress isn't forced to choose Y or not Y in the first place. And when it does and it enables Z, we might want to treat that differently. But even as the Congress, and by the way, the president bootstraps all the time. So even as the Congress and the president, there's a huge range. So if we want to say we're worried about under-enforcement, we're worried about where this leads, we're worried about the unending aggrandizement, my pushback is, okay, so what is the distinction that you're actually going to draw? And if you're not going to draw one, Neil Stiglitz made the point, we have military bases, and then we have a whole bunch of rules that we have because we have military bases. Well, that's a form of bootstrapping, right? So I want to point out that even Matt's suggestion about under-enforcement doesn't solve the problem of how we're distinguishing among the bootstraps. So to pick up on his point about purpose, there's something very attractive, I think at least at first blush, in particular about thinking about purpose. What if it seems clear that Congress has transparently enacted what I'm calling Y in order to enable Z. And they don't really care about Y. Y is just a means to get to Z. And the problem with that, as I talk about in the paper, which I'll summarize very briefly, builds on Ken Shepsley's key article, Congress is a they, not an it. You have 435 members of Congress. The sponsoring member probably, let's assume, cares only about Z because some constituent group said we really want Z, and maybe doesn't give a fig either way about Y. You got a whole bunch of members of Congress who are voting, who knows what their purpose is. Many of them are voting because they want to do a favor to this member of Congress because they don't care. Some of them like Z, some of them like Y, some of them have no idea what Y or Z is, and they're drunk that day. You know, it's just, this is trying to divine congressional purpose, I think, is a fool's errand. I will note separately. I'm unpersuaded that it makes sense in any context, but at least I think it's more defensible in the equal protection context, but I'm not persuaded that it's a useful kind of endeavor to engage in. And so the, and some of the other arguments that have been put forward about bootstrapping are really discomfort with what I'm calling the Z, the endpoint. Okay, you don't like the endpoint, fine, don't like the endpoint, but if we're talking about the mechanism of using Y to enable Z, we're acknowledging there's some empirical connection between them. We acknowledge that once we have EMTALA, in fact, every one of you now is carrying a price tag on your head for purposes of emergency rooms. Emergency rooms now see you as potential costs that they're legally obliged to incur that they didn't have before EMTALA. So there is some empirical connection. The question is, do we nonetheless want to say, but there's something about the bootstrap that really we should want to stop? And my answer is, again, there's just not going to be any nice way to divide among them. One thing that Matt did mention that I will highlight is, one could try to make the argument about this, with my point about simultaneous versus non-simultaneous. I think there's some traction there, which is to say maybe we should feel differently when Congress does it in one piece of legislation as opposed to two separate enactments. Because two separate enactments, you don't actually know when you're passing the first one what the second one is really going to produce when all is said and done. I'll just say briefly, if we had a rule against simultaneous bootstraps, it would be uniquely disabling of Congress because the president can always stage executive orders because he's a constituency of one. So if you require the president doing two separate executive orders, easy. You requiring two pieces of legislation, not so easy. Now that's not necessarily an argument, therefore this is a bad idea, just note the costs of having a rule against simultaneous bootstraps. 2 points that I would make about that. One, that Ernie will not be sympathetic to, but I do think, in fact, it's not just political safeguards of federalism in theory, but in fact, concretely, Congress has had this ability to bootstrap. Certainly it did from Wickard until Lopez had this huge, and it didn't, in fact, go wild. And there are good structural reasons to think why Congress wouldn't do that. The second thing is, we actually might in some situations prefer simultaneous bootstraps because it makes it clear we don't have the danger of the frog being boiled by degrees over time. By the way, apparently it's not true. Apparently if you put frog in, it will in fact jump out, but we all believe it. So let's just assume that it's true. That's a great metaphor. It's clear, in fact, to quote Scalia and Morrison versus Olson, this wolf comes as a wolf. When you've got the legislation that's got the Y and the Z together, there's actually greater transparency there. But the real burden of the point that I want to make that Matt nicely picks up on is there may be an intuition here about bootstraps bothering us. I personally believe that none of the distinctions that we would draw would be both principled and remotely attractive. And that's really the burden of the paper. But I think I should stop there.
Great. Jamie.
Thank you. First of all, I'm going to apologize. I'm going to cut out immediately or shortly after my presentation because I teach immediately after this panel. So I apologize for being rude in that way. I'm going to give three very quick views. A view from a cynic, a view from abroad, and a view from constitutional theory. So the view from a cynic. The cynic would say, guys, this is really cute. You're addressing all these arguments to this court. You know, this is the court that decided Bush versus Gore. Okay? I mean, get real. Okay? And if you don't like Bush versus Gore, and I see certain faces smiling, certain faces not smiling, you know, then those crazy interventionist 1960s decisions, or maybe the switch in time that saved 9, but you have a thought in your head about a case where the court engaged in nakedly political, spur-of-the-moment decision-making. Courts do it. This is wrongly sometimes described as critical legal studies, or CLS view. It's actually the opposite of CLS. CLS argues that ideas are important and actually constrain people, right? This is JMSU jurisprudence, just making shit up, okay? This is the court just coming in and saying, our guy's gonna lose, bam, right? Now, the problem from the cynic's point of view is that there wasn't enough time before Bush versus Gore for people to actually give the arguments a veneer of intellectual legitimacy. If there'd been more lead time, there would have been symposia like this one, says the cynic, in which people would have discussed Jefferson's views of the butterfly ballot, or Federalist 10A, which inveighed against factionalism and hanging chads. And that, thus, by creating this rich veneer of legitimacy, they would enable the court to escape from the existential reality that it's engaging in JMSU jurisprudence. So that's what the cynic would say. So given the reality of what's going on, says the cynic, given the naked war of political preferences, given the repressed memory of, insert your favorite case where the court just engaged in JMSU jurisprudence, this is like Letitia Baldridge and Emily Post arguing about whether Charles Manson should eat his salad with a knife or without. It's simply a facade. Second, the view from abroad. So this is a view from a foreigner. So the foreigner says, hey, great, thanks, great to be here. You guys are the only advanced country in the world that doesn't have a universal healthcare system, okay? That's just point one. There are lots of reasons for that, but predominantly it's your crazy anti-statism and your fixation on markets to solve problems that they clearly can't. Now, don't get me wrong, we all have national values. We foreigners are committed to universal healthcare, great public transport, cheese, and surrendering to the Germans. Those are our values, yours are different, we understand that, but those are your values, right? Crazy anti-statism, fetishism of markets. Given that it's your market fetishism and your crazy anti-statism that have stopped you creating a universal healthcare system before, don't you find it just mildly ironic that your constitutional fears here is the state will go crazy and start imposing mandates on people to eat broccoli? I mean, is this really the fear that we should be worrying about? Isn't this like an anorexic going, I'm just worried I might eat a lot. You know, I'm just worried I might eat a lot. I need a constitution to restrain me. Ironically, you might even argue that had it not been a crazily anti-statist, crazily market fetishizing country, Congress would have done this a long time ago through a straightforward single-payer system which was backed by a tax. And I think everyone thinks that would have been constitutional in the same way Social Security is constitutional, although one can never tell. The lines are always shifting. Response to Stuart, one worries less about bootstraps if there is a legal escalator close at hand, right? If Congress has the power to do something more extensive, I think the bootstraps fade in concern. So, that's the view from abroad. There's something bizarre and kind of internally focused about your perspective here. The very things that created this problem are the things that would in fact avoid the constitutional fear that you're musing about. Third, constitutional theory. Constitutional theories, in my view, this is a shamelessly pragmatic view in the way I'm going to assert it, though I actually have a deep and more reasoned justification for it that I don't have time to present. Constitutional theories are basically stories about what we're most afraid of. Process theory was worried that the legislature would work well most of the time, but there would be occasions when discrete and insular minorities would be denied access by voice or vote. That was the malfunction that we wanted to cure, okay? That view makes the First Amendment and the 14th Amendment huge, right? It makes our concerns about the 10th Amendment, about the contract clause, relatively unimportant. You know, rich people can take care of themselves, the states are powerful. It's the discrete and insular minorities we need to focus on. It changes the way we view the Constitution. Originalism is, in my view, a response to a set of fears, a fear that the Constitution will become simply another arena in which we impose the politics of the day. Instead, we cast a lifeline out to the past, root ourselves in the views of the framers, eminently clear views of the framers, eminently clear understandings of the ratifiers, and thus lock ourselves in precisely the way a Constitution would. I have some wonderful quotes here from Justice Bork that I don't have time to read, but actually I'm going to read one of them.
Can you say justice?
Yeah. It's a counter history that I'm engaging in. So it's a lovely line here, at least I think about it. He says, it's naive to suppose the Supreme Court's present difficulties could be cured by appointing justices determined to give the Constitution its true meaning, to work at finding the law instead of reforming society. The possibility implied by these comforting phrases does not exist. History can be of help, but it tells us too little about the specific intentions of the men who framed, adopted, and ratified the great clauses. The record is incomplete, the men had conflicting and vague intentions, and no one could have foreseen the disputes that changing conditions and outlooks would bring before the court. He wrote that in 1968 when he was most worried about things like the Interstate Accommodations Act, and he wanted instead to enunciate a rich natural rights libertarian justification which would stop an overweening state doing things like stopping innkeepers from being racist. His concerns changed over time, and so did his theories. My point is, our theories are a map of our fears. So, which of these three views offers the greatest insight? I reject the cynic's view. My colleague David Lang has a lovely phrase, an insight that is too deep to be of use. I think the cynic offers us a perspective that seeks in an occasional malfunction to denigrate an entire tradition. I think that's wrong. I think it's wrong to see the system from the point of view of the occasions, when honestly, there is JMSU jurisprudence. This, in fact, is a rich tradition which does constrain us, which produces different results that sometimes brings us more just results than the market or the democracy alone would produce. And that's true. It's worth defending. But the cynic does offer one piece of insight, which is the people who teach and write about constitutional law and who run the law schools where we have conferences like this have a vested interest in the legitimacy of the judiciary. They clerked for some of the people who engaged in JMSU jurisprudence. They hope to place their students with those same people. They hope to invite them as speakers. And so when the courts do engage in JMSU jurisprudence, and I'll leave it to you to fill in the contours of what that means, the judges are insufficiently chastised for it. This breeds a culture of self-importance and a lack of humility that I think ill serves us as a republic. And that, of course, does not refer to the professoriate, who are uniquely humble. The view from abroad, I think, does offer a perspective that this is a somewhat bizarre debate, right? Just a little. But that doesn't mean it's wrong. That doesn't mean that the concerns being enunciated are wrong. Yes, we've done things differently than every other advanced country in the world. Doesn't mean we're wrong. Yes, the fact that we're arguing about whether Congress has the power to do this looks really bizarre from the perspective of the democracies of every other country to which we normally compare ourselves. But it doesn't mean it's wrong. Finally, view from fears. I actually think the view from relative fears is the most productive insight here. I think that we should judge our constitutional theories on whether or not the fears they ameliorate are legitimate ones. I think we could have a crazy Congress that stultifies the kinds of experiments that Ernie very persuasively talked about. At present, I don't see an entirely functional national government. I see one that can't even extend the debt limit, that is utterly crippled. The idea that we're going to have a rampaging Congress imposing mandates on to eat broccoli strikes me as unrealistic. But I acknowledge that there are other fears, and they are legitimate. Thank you.
Thank you. That's great. Erwin.
Thank you. Under current constitutional doctrine, the issue is, does Congress have a reasonable basis for believing that it's regulating economic activity with a substantial effect on interstate commerce? In the most recent Commerce Clause case, Gonzalez versus Raich, Justice Stevens said the question isn't, is it economic activity that has substantial effect on interstate commerce? The question is, does Congress have a reasonable basis for believing this? Now, Neil Siegel's right. The Supreme Court could change the doctrine and abandon it, but as of this moment, that's the test. Now, so much this morning has been focused on if the Affordable Care Act is upheld, well, how will we stop the slippery slope? That's Professor Somin's paper. That's what Professor Young said earlier. But I want to suggest the slippery slope comes not from the court upholding the Affordable Care Act, but from the test that it articulated in Gonzalez versus Raich and other cases. So long as Congress only has to have a reasonable basis for believing it's regulating economic activity with a substantial effect on interstate commerce, it's true. Almost anything fits within that. This is a point Professor Sachs was making to me after the last panel. This is the point that Justice Clarence Thomas has repeatedly made, is why he rejects the third prong of the Lopez test, why he rejects the substantial effects test, because anything would fit within the substantial effects test, he says. So the question is, can the Supreme Court declare the Affordable Care Act unconstitutional without rejecting this test from Gonzalez and earlier cases? If the Supreme Court rejects this test, well, then I do think there's enormous consequences, because then so many other federal laws become unconstitutional. And the question is, could the Supreme Court come up with some narrow way of invalidating this, but still be consistent with the test that articulated in Gonzalez versus Raich? It's that I'm skeptical about. To me, that's why this is an easy case. Because if all there has to be is a reasonable basis for believing that this economic activity is substantial effect on state commerce, then I go back to the numbers. There are 50 million people without health insurance in this country. That has enormous economic costs, as well as ensuring them will have enormous economic effects. There's huge social costs. No one here this morning has want to talk about the people who get much sicker or die just because they don't have health coverage. No one has really want to spend that much time talking about this. Is an $850 billion industry. To me, that's the answer to the slippery slope argument. Because on the one hand, it's easy for the court to say, Congress can regulate an $850 billion industry under the Commerce Clause, and we don't need to consider eating broccoli or anything else. We'll deal with those when we get there. On the other hand, if Congress can't regulate an $850 billion industry, then it would seem there's so much else that Congress has done that would then be constitutionally vulnerable. I just want to conclude by emphasizing something that Jamie said that I also was thinking of, especially as I was reading Stuart's paper. Congress unquestionably could have passed national health insurance and increased the taxes on everybody to pay for it. What would that have done practically? It would have provided medical care coverage for everybody, and it would have meant that everybody in the country was paying something to support it. What does the Affordable Care Act do? It provides health care coverage for almost everybody to make sure that almost everybody is paying for it. Is there a meaningful conceptual distinction between that and what Congress has chosen to do? I don't think there's a meaningful distinction in terms of individual liberties, because in terms of individual liberties, everybody ends with health coverage and everybody is paying. There's not a difference meaningfully in terms of Congress's power. Either way, Congress is doing the same thing. So I think we want to talk about slippery slopes or bootstrapping. I think the question is, if Congress could do that, is there other than a very formalist distinction that Congress did? I don't think so. Let's go back to Professor Sachs' question at the beginning. That's why I think this is an easy case.
Great, and we have time for questions. Ernie.
So I have two questions, both about total taxes, actually. The first is a political safeguards question. And I'm wondering, when are political safeguards appropriate as a substitute for judicial review? I've never heard anyone argue for advocating judicial review of protecting the press under the First Amendment, of protecting racial minorities under the Protection Clause, of protecting privacy under Griswold, even though it's extremely unlikely that Congress would dramatically restrict the press, engage in overt racial discrimination, or ban contraception nationwide. So why don't we hear those arguments if it's just a question of political likelihood? Wexler said there's no choice that a court has whether to enforce the boundaries of federal power in the same article. And so I'm wondering why we're advocating that idea. And if we like political safeguards so much, why aren't we talking about process forcing rules like a ban on no simultaneous bootstrapping, like a ban on greater power includes the lesser arguments like Erwin's? I mean, those would raise significant political safeguards type questions. The second question is really for you, Gillian. It's about slippery slopes. It seems to me that Wexler's other landmark article, Neutral Principles in Constitutional Law, presupposes that we're going to be worried about things like slippery slopes. He says the great constraint on ideology, the great constraint on judicial decision-making in general is that you have to be prepared to treat like cases alike, which means you've got to be looking down the road to make sure that in the next case where you might not like the outcome so much, you're going to be willing to apply the same principles. So it seems like that's just a more sympathetic way of talking about slippery slopes.
Yeah, I'm not sure I think that's right. I mean, this goes back to something Ilya was saying about similar vein, right? Rule-based decision-making as being critical. And I'm not denying rule-based decision-making, but the slippery slope is a very specific form of argument, and that's what I'm targeting, right? It's saying, not this case could be problematic, and look at those future effects, therefore we're going to do a consistent rule. The idea of slippery slope as a distinct form of argument, separate from this case is objectionable, is this case isn't objectionable in its own terms, but that one is. When that's the argument, it's this one I can fit under economic activity, this one I can find the interstate need, this one is okay, but it's really the other mandate that's the problem. Now, you may disagree with that as a typification of slippery slope, although I think that Fred Schor is right that that's the analytic move of slippery slope per se. Then I don't think that in order to have principled decision-making, we have to have that line of argument. I do think that you have to figure out what your principle is and apply it in like cases. If your principle is economic activity, I think that it would sustain it here. I think it will probably sustain a number of mandates, but not necessarily all. There are ways in which, even with the principle of economic activity, I think there are some social mandates that Neil was talking about, or conceivably even some totally artificial purchase mandates where you could say it's one thing to say we're talking about an obvious market that exists and being mandated, and that's a self-created one. I think there are ways you can add it on and still claim to be doing principled decision. I just want to make the point that it is a distinct analytic reasoning move here that is identified as the slippery slope, and it may be that we think this case is too like that one, both are objectionable. That's not the same kind of the A is okay, B is not, I'm going to hold A unconstitutional because of B.
And
yeah.
just to respond, so I should apologize because I mentioned political safeguard federalism just because of our history on that, and I knew I'd get a rise out of you, but I shouldn't, because in fact, that's actually, I want to be clear, the political safeguard comes in when somebody says, oh, I think this really violates the Constitution, and someone else says, no, there's political safeguards. The form of these bootstrapping arguments has been separate from our claims about Commerce Clause, et cetera. We also have this other concern about aggrandizement, and that's what I'm calling this constitutional concern. So we are not, when they're making the bootstrapping argument, they're saying, separate from the Commerce Clause thing, we're just worried about where this leads. And what I'm saying is, I think where it leads as an empirical matter is not where you think it leads.
Yeah. So just on a political safeguards thing, I think the political safeguards issue ties into slippery slopes, in that if the political process may take care of some problems better than others. So maybe there are some issues where we can afford some under-enforcement of constitutional norms because the political process will self-enforce them, so to speak. I've tried to argue that in this area of mandates, that's not the case because there are special interest-driven mandates, there are bootlegger Baptist coalitions, and so forth. And it's interesting to me, actually, that in terms of the slippery slope as a matter of doctrine, sort of my two critics, Erwin and Gillian, have come in a completely opposite direction. Gillian says there's no problem, we can find other doctrinal limitations on this, though it's not clear to me entirely how they would work. Erwin says essentially we don't need to worry because we're already there because of the rational basis test. There, I actually thought long and hard about the same question you raised, and glad that he did, because I wrote a couple of amicus briefs in these cases, and I was like, what are we going to do about the rational basis test? I actually went back and very carefully read the passage from Reich that Erwin mentioned, and also similar passages from other cases. They do indeed say that the rational basis test applies to the question of whether there really is a substantial effect or not. That was the issue in Reich, where the question was that this homegrown medical marijuana, does it have a substantial effect on the general interstate market in marijuana? They said, well, that's up to Congress to decide. But they do not apply rational basis to the question of whether there actually is an economic activity in the first place. If they did, they would have had to overrule Lopez and Morrison. Because I think if you read Justice Breyer's dissents in those cases, he makes a pretty good case at the very least that there's a rational basis for believing that carrying guns into school zones and economic activity, obviously guns are economic commodities. In addition, many of the people who carry guns into school zones, like Alfonso Lopez himself, were doing so as part of a drug dealing operation, right? Which is certainly the guns were there to protect their drug dealing activities against rival gangs and the like. So I think I'm not, the current doctrine, including in Reich, does apply to rational basis test to a lot of stuff. Frankly, a lot of stuff that I think it should not be applied to, but it does not apply it to the issue which is at stake in the present case, which is this actually economic activity of the kind that can be regulated under the Commerce Clause.
Can I
Mark.
respond to the political safeguards point real quick?
Let's just get another,
Okay.
we've only have like 7 minutes
Okay.
left to our panel. Let's get some other voices at Mark.
Well, just two quick things since we're allowed to. Mark Hall is Wake Forest favorite disease, lung cancer, because I can't say it.
That's a really good one.
Second favorite is obesity because it's the headquarters of Krispy Kreme donuts. Anyways, so the quick point, just I was thinking of examples of slippery slope arguments that could have been made that weren't, and one is that the spending power could be used to purchase warehouses of broccoli, just like we purchase warehouses of cheese. And the postal power could be used to mail the broccoli to us each week, so that you would have the offensive invasion of individual liberty that stinky broccoli would show up on my doorstep every week. But none of that has deterred us from an expansive postal power or spending power. At any event, that's an argumentative tweak of the slippery slope. But the question I have is for Stuart, and I wanted to think about the doctrine of bootstrapping in two ways. One is a way that you mentioned, which is bootstrapping is really embodied in the necessary proper clause. And you may have mentioned briefly that it needs more highlight, that the necessary proper clause is nothing but the endorsement of bootstrapping. And so you do a very effective job of saying, well, what we need is a theory or a principled reason for the kinds of bootstrapping that aren't permissible under necessary proper clause. And then I want to point out in terms of purpose and the like that Justice Marshall gives us that doctrine in McCulloch. He says it's fine to create corporations who do whatever you want to do as long as you don't do it simply as a pretext. So this dictum or phrase about invoking the necessary proper clause as a pretext for doing something that you're otherwise not allowed to do. So that pretextualism point has been mentioned from time to time simply in passing in dictum, and I think it does give a sort of a doctrinal hook to say that there may be types of bootstrapping that offend necessary and proper or not protected by it, but it has to do with what would pretext mean. It would get in part to purpose, so I think you need, at least I would be inclined to allow purpose in to some extent, and then it gets, I think, to a sense of proportionality, that this sort of purported why isn't really the real why, and why is nothing but pretext for Z. And framed that way, I think it becomes extraordinarily easy to reject the argument here, the idea that eliminating medical underwriting is nothing but a pretext to force us to all buy insurance is just an absurd claim. And I think the fact that I think it was the 11th Circuit that embraced some version of that argument verifies what Jamie was just saying, which is we're just seeing shit being made up. But, I mean, it seems to be such a laughable argument that I can't believe hardly that it's being made, much less that at least one respected court has accepted if the test is pretext.
So let me just respond quickly on this. I mean, you're right. I could embrace, and nonetheless, I don't embrace the pretext point. Part of the reasons I said, different members of Congress have also, but then we also just point something else out, is the why has political costs. The why is something that Congress actually has to enact. And so for whatever reason Congress does it, I want to highlight it isn't the classic example of cheap talk. So what's cheap talk? Cheap talk is you throw in some legislative finding, whereas the moon is made of cheese. There's no consequence to it. No, the why is actually a real enactment that you actually that you have to do. And so it seems to me that I'm not so worried. If you're willing to take the political hit to enact Y on its own, or in combination with Z, then I have a hard time with a reflexive notion that we're going to be able to find some situations where the Y is. Why should we be worried if some people treat Y as a pretext? They're still voting for it as substantive legislation. Again, these are costly signals, not cheap talk.
Let me just get Abby's question, and then we can talk about all of them, but I just wanted to, you've had your hand up both panels.
I had a criticism for Ilya, and then or comment / criticism, and then a question for Stuart. So the comment is you talk about frame shifts as being a problem with the response to the slippery slope argument, where we're talking about health insurance and then we switch to health care. But it seems to me that you're guilty of exactly the same frame shift by talking about consuming broccoli. Even if you just talked about buying broccoli, you would still have a frame shifting problem. Where what we're really doing is we're asking people to structure their finances in such a way that their broccoli and their donuts and their T-bone steaks will be highly discounted in the future. And so really it's about a financial structuring law that seems to me to be quintessentially economic and not behavioral at all. And not at all about whether or not you get preventive care visits, or whether or not you get triple bypass or anything like that that might impinge on the liberty interests in controlling your own behavior and your own bodily integrity. So that's just a comment about, you know, how do we characterize the slippery slope, and what is it that's the problem, and whether or not there's a line that can be drawn. So I think this goes to Gillian's point that if the issue is whether or not it's economic versus whether or not it's active, then it seems to be clear that the insurance mandate is economic in nature. For Stuart, I'm sorry, I'm trying to talk fast. For Stuart, my question is, I have sympathy for the bootstrapping instinct, particularly as applied to EMTALA creating a problem that can be fixed through Commerce Clause regulation. I haven't had time to think through why I think that that's okay carefully enough to be able to give you anything useful that much, but I think it has to do with the fact that EMTALA is a spending condition, and this is a commercial regulation attempted through the Commerce Clause. And the spending power is significantly broader than the Commerce Clause power. So this is something slightly different from a path dependence of we built railroads that allowed us to have markets, that allowed us to regulate the markets. We did something that we had authority to do as under taxing and spending power that maybe is broader than it ought to be or was originally intended to be, and we're using that as a justification that has created a problem that becomes a justification for direct regulatory control that might be problematic on Commerce Clause theory. I don't know why I feel like that matters, but I do.
I think Matt wanted to jump in.
Yeah, everybody,
Well,
now,
look,
free flow.
this is just to say something about purpose, because again, I mean, at the end of the day, yeah, which goes to bootstrapping. I mean, I agree, and this goes to Mark's point. I mean, I agree that sort of a purpose-based test for bootstrapping is going to be, ultimately a non-starter. But you, and again, I think in response to Mark, take sort of this radical, Ken Shepley's famous article where he says Congress is a they, not an it, doesn't make sense for attribute purposes. I mean, in a way, it's garbage, right? If what Shepley is saying is Congress does not have a purpose which is somehow wholly separate from the purposes of its members, that's right. But one can certainly have an aggregation rule which ascribes purposes to a multi-member legislature based on purposes of the members. And indeed, and this is, to go back to Mark's point, if you look at Commerce Clause doctrine and federalism doctrine, over the ages, the court has periodically tried to build in a kind of purpose requirement. So the language of pretext in McCulloch, or Hammer against Dagenhart, which says, well, we realize that you're regulating interstate shipment, but your purpose is to get interstate stuff. Or Butler, where the court says, we realize this is a spending condition, but again, your purpose is to regulate agricultural production. Or Dole, which says, well, part of the test for spending is whether the condition is related to the purpose. So it's just that the court talks about purpose, but then it's just difficult, right? It's a costly and difficult, first of all, to agree as to what the aggregation rule, and then secondly, to police purpose. And so, there is this language of pretext, but that ultimately goes nowhere. But to take the radical line that, well, we can't make sense of purpose even in an individual case because of problems of multiple motivation and so forth, or we can't make a sense of purpose in the multi-member case because we can never ascribe purposes to legislatures is just much too, radical a view as to why purpose couldn't be part of the doctrine, and in that way, too radical a defense or an argument against bootstrapping.
I think there's 30 seconds.
Can I say something?
Whoa. Every one of you is going to get 30 seconds, but I'm going to let Jamie go first because he has to teach, and then we're going to go down, and then you get the last word, which means you can take 45.
Response mainly to Ernie. I think there's two versions of the fear/political process will take care of it. One is, I know what the Constitution means, and it makes this illegal, but what the hell, the political process will take care of it. I reject that. The second one is, constitutions aren't self-interpreting. We need an interpretive schema. The way we judge among and between interpretive schema that give us the principles we are enforcing is partly based on fears. Now, in our constitutional tradition, there's a great deal of fear about encroachment of federal power. I totally agree with that, right? But I think in judging between and among plausible, rooted, legitimate constitutional interpretations, the question of legitimacy of the fear today is a valid criterion. And that's a different point, I think.
Okay,
Thank
great.
you.
Stuart.
So you're right. As I said, I actually don't mean to say purpose can never be defined. I talk about this more in paper, and you make me realize I should actually flesh it out even more. The purpose that we're worried about here is the purpose of aggrandizement. That is the fear, is that Congress is trying to expand its power for the sake of expanding its powers. And I think we will actually never find that purpose, which is to say, we may very well find some members of Congress say, I want to enact Y, I don't care about Z. Some I say, I want Z, I don't care about Y. I think it is truly a fool's errand to try to find the evidence that that the majority of members of Congress are saying, what I really want to do is just have more power because I really like power, because I get a better quality of cocaine or interns or whatever else as a result of that. I don't think we're ever going to have that. And so that's why I think it's not going to work here.
Okay, and Ilya.
Yeah, I just want to briefly comment on a part of Abby's question directed at me. So in the paper, actually, I do talk about the distinction between consumption and purchasing. And I know even if it's a slippery slope limited to purchasing, it's still a pretty substantial slippery slope, and it applies to purchasing of virtually all products. With respect to consumption, I actually don't think you can distinguish it from purchasing on the grounds that one is economic versus another one is not. Indeed, the Supreme Court in Gonzalez versus Raich says as much. They define economic activity as anything involving the production or consumption or distribution of a commodity, and certainly from sort of intuitive economic analysis, consuming a commodity is an economic activity. And your other point is maybe there's a difference between it's that one is a financial regulation, whereas the other one is not. Again, even if that's true, I'm not sure that that has any relevance to either the slippery slope argument or to constitutional analysis. It seems to me it's just as economic to regulate a market by saying you have to purchase something now as to say that, well, our goal is to structure consumption decisions over time. And I would also note that with respect to consumption of broccoli or cars or anything else, you can also say, well, what we really want to do is we want to make sure you buy the food you need or the car you need or anything else right now, as opposed to waiting later when maybe you're more emaciated or later when you have more immediate transportation problems. So I'm not sure those sorts of distinctions work conceptually or are likely to be adopted by the court if they uphold the mandate. So my only point about the frame shifting here is that the exact same sort of frame shifting that is done with respect from health insurance to health care can easily be done with respect to pretty much any other market. I think that's logically true, and more to the point would likely be done in future litigation if this argument was endorsed by the Supreme Court.
Great, thank you all.
Produced by Duke University. Online at duke.edu.